Here it is.
There he is, walking down the street. Hey, hey. I had to talk to my son, you know. What happened to the chairman? He's gone.
Okay,
I'm out of here.
go ahead. I'll
Okay.
help you out
Mr.
here.
Chairman.
and let's see, Senator
You just saw
Hertzberg.
me. I know. Miknovich.
You are presenting. You've got two bills on my list. So which one are you bringing forward? SB 820,
I don't know what it is. I only have one bill here. 820, yeah.
820.
Right. That's what I'm doing.
Okay, I'm
Do I
sorry.
have something else? It's
Well,
probably
I
on
guess another one was
consent.
taken off. So I
On
apologize.
consent, yeah, 820. First and foremost, I accept the amendments of the committee reluctantly. Jurisdiction, government trying to be relevant instead of making it indefinite, only make it 10 years, but that's okay. It's Full Employment Act around here. But a number of years ago, we deal with this issue with brownfields, right? Where there's a toxically polluted place. I've dealt with this in my private practice before as a lawyer, and I've dealt with it in government before, and it's a challenging experience. We've come up with Superfund ideas for the big sites at the federal level and certain level at the state levels. We've got certain programs that are toxic releases in the state. But so the question is, where you have a community where there used to be a factory, there used to be a problem, you've got this extraordinary liability. And so it was what's her face from the Valley in 2004 did this bill. What's her name? Oh, come on, it'll come to me. Any event. And so the idea was to come up with a way to provide an incentive where if there was a certain cleanup program for private developers to come in and develop these brownfields, and it's that we would not extend the liability because no one would come in these communities where you had this stuff and develop. And so there was a challenge, right? I mean, the great example was this pickle processing plant in Hayward in 2008 that was converted into Eden Housing of 78 affordable housing units. There's other examples of that around the state.
Senator, who represents that pickle factory in Hayward, or former pickle factory in Hayward?
Ellen Corbett, was it? Montanez, Cindy Montanez, exactly. It was Cindy Montanez's bill. Thank you. Who's now the head of Tree People. So in any event, what we're doing is basically taking this very successful program and now extending the time. Beal Cedillo had a bill here and extended it to 2017, and we're just making sure the program now extends another 10 years and continue that success. I'm told that there are, how many sites? Some huge number of sites that are still eligible for this, 2,355 sites. It's been successful. Yeah, it's been successful. It meets the balancing interests, and so, this is one of those things where we took it bull by the horns and get ahead of it and keep this program alive. So I ask for your support, and we got very brilliant witnesses here to testify and answer all your questions that I can't otherwise answer.
Yeah, the committee is concerned with all the new hazardous brownfield sites that are going to be becoming part of California's jurisdiction when the Superfund, the federal government, drops them and then become part of our responsibility. So this is we have a lot of fun going on with cleaning up these brown sites, but we're going to have more brown sites that are now going to become state responsibility versus the federal government. So this is a concern. Yeah, it's really too bad, but I guess it's our mess. So please, first witness.
Thank you, Chair and committee members, and good afternoon. First of all, thank you for your leadership in introducing the legislation and extending CLARA. I represent the California Association of Local Economic Development. We have over 700 members in the state. Most of them are city and county staff that are working on economic development. Some nonprofits such as LAEDC and East Bay EDA. We think this is an important tool for economic development, especially for jurisdictions that can't afford to clean up these sites on their own. CLARA will help put those contaminated sites back into productive use. They'll increase infill development. Our hope is that they'll allow for more private investment and allow a tool that will actually let us have a way to increase public-private partnerships when it comes to dealing with these sites. We also believe that it creates a clear path for cleanup, allowing for oversight and also allowing for ongoing monitoring as well. And I'm going to turn it over to our colleague, Robert Doty, who's going to talk a little bit more about the technical parts of it.
Good afternoon, Mr. Chairman, members of the committee. My name is Robert Doty. I'm an attorney in private practice. I'm with the California law firm known as Cox, Castle & Nicholson. As a firm, we do anything and everything real estate. I do polluted real estate. So I use this tool in my practice, as do several of my partners. I was on the group of people that drafted it originally. I'm really here to answer any technical questions you have. I can tell you as a practitioner, it is a very valuable tool. It provides new investors and the communities they work with some certainty about what they're getting into, some comfort about what the end of the line looks like, and it gives them the comfort to go forward in many cases.
One of the reasons why we have our 10-year sunset, a continued 10-year sunset, is to give the legislature that ability to evaluate the successes of Clara, and have the our role as senators to keep an active role there in that. Are there things that you would suggest that we haven't been doing with the program, or everybody totes the successes? Are there things that we should be paying attention to on maybe medium-sized cleanups or particular problems? This is a difficult area of the law and of remediation.
It is a tough area. I think there were a few years where it wasn't being used very much because the real estate market was in a doldrums during the first part of the Great Recession, I guess as we call it. You're seeing it utilized more now. There are some policy ideas floating around out there that I think we want to come back with next session. I think for the time being, the thought was let's deal with the sunset issue. Let's have a dialogue among a lot of stakeholders about what some ideas for possible strengthening of it are and expanding it in some cases. But I think we're not quite there yet in terms of having that consensus form to bring back to you. So I would sort of defer that issue if you don't mind.
Yeah, no,
I'm happy to preview them with you if you're curious, but
No, I remember in the assembly when I was on the chair of the Environmental Safety Toxic Material, we were talking about the differences between the different CUPAs, what level of cleanliness they expected, and the regional boards, and sometimes it looked like a full-time employment act where people these gasoline stations had been cleaned up and remediated, but different values that they had on when clean was clean to have the reuse done. And that was a couple of years ago. That was during that Great Recession.
I think on a lot of those sites now what people are doing, frankly, is defaulting to sort of the most conservative set of numbers that are out there. They're published as screening values. Mm-hmm. And if you do those, they are by definition so conservative that no one thinks there's a problem with them. And so a lot of people are just defaulting on simpler sites to all clean it up to the screening values and be done with the conversation.
Other witnesses?
Mr. Chair and members, Matthew Harg with the California Business Properties Association in support of the bill as amended. Thank you.
Good afternoon. Steve Cruz on behalf of the California Building Industry Association in support.
Hi. Mikhail Scavarlo on behalf of the California Council for Environmental and Economic Balance in support.
Hal Dassinger, Civil Justice Association of California, we support.
Rosanna Carvaggio on behalf of the California Infill Builders Federation, also in support.
Opposition. Is there opposition to SB 820? No. All right. Questions of the author? Senator Leno.
In the case of a remediated parcel, and then subsequent, and I think the chair touched on this, and then subsequently there's identified additional risk, environmental risk, who's then held responsible?
The state.
The state would be.
Ultimately, at the end of the day, the state is ultimately liable. But understand that there is, it's not like you're taking the site and cleaning it up. People who come in, commit millions and millions of dollars with the best experts. I've been through this process before. And as you say, how clean is clean? What does that really mean? And you argue over that stuff. But ultimately, this notion of having a tail of liability forever and ever and ever, half these lawsuits that you see are everybody blaming everybody and who was a previous occupant, and it's a Lawyers Full Employment Act. No disrespect to Ken Bly. Is he still at the firm? Yeah. So the point is that you got to have some balance in that. But ultimately, yes, sir, the Senate of California is responsible.
And is it clear when the state becomes the responsible party?
So to break your question into two pieces.
Sure.
If it's a contaminant that wasn't known about, wasn't studied when the site moves through the process, in that case, there's no immunity, and the private developer who missed it is responsible for having missed it. If it was something known, studied, dealt with to the regulatory agency's satisfaction, and the regulatory agency later decides, no, there really is a problem there, the regulatory agency can go back to the CLARA process person, the developer, and make them do more if it establishes two things. First thing it has to establish is there really is a human exposure or an environmental exposure to be worried about. Second thing they have to do is chase after whomever might be the historic responsible parties. Somewhere along the line in that process, the state is taking on the initiative to chase down that historic private party that was responsible if it can. If it tries and can't, it actually can then go back to the developer once it's established that it tried and that there really is a problem there. So the state becomes one of the key players, not the only key player in that situation.
Since I have you here, I appreciate your wise counsel and experience with this. We're having a budget committee hearing on this whole debacle of Exide later this afternoon, and the state's putting forward some money to begin the remediation of these devastated neighborhoods. It's a loan to the special fund to take care of this. We don't have great expectation we're going to get a lot back, if some. Exide has declared bankruptcy, but I'm also told it's an international concern and is operating around the world. Do you think we have much hope in getting some of this back?
If there is actually a pocket with money that can be
I
picked,
hope you don't mind.
This is good. I like this. This is smart. He's the chair of the budget committee, you know?
free legal advice, if there is money, if there's money in a pocket that can be picked,
Yes.
notwithstanding the bankruptcy, there's a theory by which you go after them. You go after them for solely injunctive relief, not money relief. You do it under a statute called the Resource Conservation and Recovery Act, RCRA.
Want to repeat that, please?
RCRA, RCRA, Resource Conservation and Recovery Act. And the claim you make in the bankruptcy court is that in seeking injunctive relief, that thing you are
Joins the
seeking
transfer.
is not a claim dischargeable under the bankruptcy code.
Right.
Thank you very much.
And Exide did that with the DTSC. During the pending bankruptcy, their mothership entered into agreement with the state of California that said they will accept responsibility for the cleanup and that would be non-dischargeable
In bankruptcy.
in bankruptcy. That was part of the plan that was going, that they had done that. I'd never seen that.
That's in the confirmed plan?
Yeah, that was a confirmed part of, that agreement was attached to the confirmed plan that went forward just for the assurances that you're talking.
You chase the parent company, right?
Yeah,
No,
and
no,
you're
they
okay.
agreed. They
If you have
agreed.
that in the confirmed plan, you can chase the
Yeah,
parent
but,
company.
yeah, that's the first time I've ever seen it. Right.
Yeah, but
I guess
just a bridge loan.
the question to follow up on Senator Leno is that let's say there is a cleanup and you have a responsible party, and then subsequently there's harm. There's something happens to somebody, the contamination. What happens then?
that person's claim is never touched by the CLARA statute because there's a carve-out that says this doesn't give you any immunity from bodily injury or property damage claims, or wrongful death claims.
Well, we have a lot of dry cleaners that have existed in California, and good luck finding those people. And then you find them if they have any pot, let alone a pot of money. We have
Some of my insurance companies have paid those claims,
Yeah.
just to let you know.
This is great. I love this committee.
so we have
Insurance, bankruptcy, chairman, this is excellent.
any other questions?
Any
of the
other advice
author?
you need for any other reasons?
Is there,
One-stop shop.
is
I
there
like
anything
this.
that you possibly want to add as a close?
Well, I didn't realize that, yeah, I used to be twice chairman of the Los Angeles County Economic Development Corporation. I forgot all about that we use this. But I think, look, this was scrubbed pretty well, and I want to pull back my comments with respect to the 10 years. I think given what you talked about, it makes sense in terms of having the legislature oversee this particularly. I didn't realize the issue with respect to super funds, and for us to kind of still to watch over this to look for the unintended consequences. So it's a good public policy, but you need to constantly watch for course correcting. And are we still doing? Is it still the right thing to do? So I appreciate that, and I now enthusiastically embrace the amendments, which I was skeptical about when I sat at this witness table.
Motion.
Ask for an
as
aye
amended.
vote.
We have in the motion. Please call the roll.
Item 2, SB 820 by Senator Hertzberg. The motion is due pass as amended and refer to Committee on Judiciary. Senators Wykowski?
Aye.
Wykowski, aye. Gaines? Gaines, aye. Bates? Bates, aye. Hill? Hill, aye. Jackson? Leno?
Aye.
Leno, I. Pavley? Pavley, aye.
Okay, thanks, everybody. Thank you. All right, let's, committee members. Senators Pavley and Senator
Thank you, Councilor.
Bates.